Is B2B cold texting actually legal? And depending on who you ask, you'll hear everything from absolutely not to you can message whoever you want. And neither answer is going to tell you what the law actually says. My name is Kyle Banks, and I've been doing cold outreach since I was 16 years old. I'm 27 now. And today I run TaskBlink, where roughly 90% of our clients are using our data and our systems to send ice cold B2B cold outreach using text messaging. And I'm uniquely positioned to make this video because I've been personally sued over cold texting and I've won. I've also spoken with attorneys involved in major federal TCPA cases, including cases that actually helped shape the legal precedent that businesses are operating under today. So in this video, we're going all the way back to 1991 and walking through 35 years of statutes, regulations, FCC decisions, and court cases that determine what businesses can and cannot do with cold text messaging in 2026. And I don't want you to take my word for any of it. Every major claim I will make will be cited. I'll give you 2 ways to independently verify the underlying law and court decisions for yourself in the description of the video. And by the end of this video, you'll understand how the laws around cold texting got to where they are today, the major restrictions that businesses need to know, and what you can actually do in 2026 if you want to use automated text messaging to grow your business. All right? So basically going to be covering from 1991 to now and how this all got started in the first place. The original laws were written back in 1991. And in 1991 was the Telephone Consumer Protection Act. What was happening was your grandma or, you name it, people had landlines back then, and their homes were getting flooded with these calls that were pre-recorded voices. They were robodials. And so the Telephone Consumer Protection Act was intended to protect residential subscribers. And when you see this in the video, this is the actual statute. This is what you can look up to reference anything in the video. All right. And so there's a little bit of a timing problem here. The Telephone Consumer Protection Act was created back in 1991, but the first SMS that was ever sent was December 3rd, 1992. That fun fact, it said Merry Christmas. In 2003, they're like, hey, we got to do something about this text messaging stuff. So kind of lazily, they decided that we're just going to have the TCPA. We're going to add something in here, and it's going to encompass both voice calls and text calls, ultimately text messaging. And from that point forward, everything became illegal overnight, immediately. From that point forward, any sort of text message that you could possibly send would be considered an auto dialer, which is very important to note. That is the first thing to cover. What is an auto dialer? And so in 2003, instantly, any sort of automated text messaging was considered an auto dialer. And it doubled down. In 2015, the FCC doubles down and it reads the capacity to store a list and dial it would be considered an auto dialer. That was considered so broadly, it really could have covered any smartphone at the time. And 3 years later, that was then overturned. And an example of this is in 2018, a gym had sent 3 text messages through a web platform, and a member decided to sue. And the Ninth Circuit held that equipment which merely stores numbers and dials automatically is an auto dialer. So any system that could store numbers and dial automatically was in 2018 considered an auto dialer. This marks the beginning of 2019. That set precedent. This is all leading up to, okay, so some dude gets an automated login alert to his number from Facebook. And he's like, I didn't agree to this. This is clearly an automated system that sent me this text. I'm suing Facebook. And this began in 2019 and went all the way to the Supreme Court. And I'm going to come back to this because this is a huge deal in cold, SMS marketing that you might not find so easily if you weren't watching this video right now. So I'm going to come back to this. Continuing further, because that court case started in 2019, it did not end immediately. So this continued onward with the laws where just basically everything was illegal. And in 2020, the Second Circuit held that the platforms were auto dollars, even though a human chose when to send it. And it's starting to get worse. And this is when a nightclub sends hundreds of marketing texts through off-the-shelf platforms with express text and easy texting. And another example with the broad reading associated with sending text. And ultimately, in this section here, what we're going to talk about is the words that Congress actually wrote when they were putting together the TCPA in 1991, which, to be clear, these are the exact words. Every word that protects B2B outreach today was sitting inside the whole time in the initial 1991, which later Facebook used to win their case that went all the way to the Supreme Court. So part two, the words that Congress actually wrote in the TCPA. In 1991, they actually defined the definition of an autodialer via Congress. And it's defined as an equipment that stores or produces numbers, importantly, using a random or sequential number generator and dials them. Let me be clear on what that is. That means that you are literally generating a random number and then dialing it. And you might think to yourself, why would anybody do that? Well, there are certain things like insurance that quite literally anybody could benefit from. So there were basically these systems that did exist and that would randomly dial phone numbers with these pre-recorded voices. And that is what was banned in 1991. That's the exact definition of an autodialer. Additionally, it states that it was for residential telephone subscribers, coming back to why this was created in the first place. And again, this is all straight from the statutes and later gets used later on in history. So we're going back to 1991 in this part. So a call versus a message. A telephone call or message defines a solicitation, but the right to sue reaches only more than one telephone call, is what was exactly stated. The residential subscriber standard bars solicitation to a residential telephone subscriber registered on the national registry. So this is now 2003. 2003 is when the famous do not call registry hit the scene. And again, focused on protecting the residential telephone subscriber, even so back in 2003. They then have a rule that further to match the statute, wherein the same tests for the capacity to store or produce numbers using a random or sequential generator. The FTC had stepped in 1995. This is important because the do not call registry and the FTC, which is trying to stop bad practices of businesses versus bad communication practice with the FCC. The FTC steps in 1995 and states that exempts calls between a telemarketer and any business to induce the purchase of goods or services. So a telemarketer may call a business and reach out to a business to offer services in some shape or form. This is back in 1995. This is with the FTC. Now, business numbers on the registry. The registry applies to residential subscribers and does not preclude calls to businesses. And business numbers inadvertently registered are not violation. This is back in 2005 that this was originally put here. The presumption was always rebuttable, and wireless residents are presumed to be residential. This is also stated back in 2003. And this states that marketers panic at the first sentence and skip the second, because ultimately the residential subscriber have to prove that they're a residential subscriber. And from this point forward, the telemarketers are then saying this is crazy. So now in 2004, we have this do not call registry that was formed in 2003. And pretty much immediately, mainstream marketing services versus FTC is now challenging this do not call registry. The telemarketers were trying to argue that this was a violation of free speech. I don't agree with that personally. I think the do not call registry has its place for protecting the home, and I think that's a pretty wild argument. And the outcome was that the registry survived as a valid protection of the privacy of the home. But nonetheless, that was the attempt in 2004 to try and stop the do not call registry by marketing services, and it didn't work. That's 2004. So opt-outs are entity specific. A stop request applies to the particular entity making the call and not to affiliated entities. So what that means is somebody opts out to one business, it's only opting out to that one business. If you're working with an agency, for example, and that agency is running a campaign for this entity and also running a campaign for this entity, they're reaching out, they're offering bookkeeping solutions for roofing contractors. And then they're also, saying, hey, I can run Google ads and get you 100 book calls in the next 100 days to a roofing contractor. One opt-out does not translate over to the other opt-out because they're different entities. That was in 1992. So this is where it starts to get more fun. Part 3, the court takes it back. 2018 to 2021, things start heating up. Judges start reading the statutes for themselves. Because just like what I pointed out in that last note, is that the actual TCPA that was originally created was kind of contradicting some of these, court outcomes. And in 2018 to 2021, this starts getting realized. So the industry challenged the FCC's 2015 order directly, basically stating that the auto dialer's definition that was put in place by the FCC was unreasonably expansive interpretation. Its interpretation of the TCPA, which was originally created in 1991, saying that you could just store phone numbers and dial them, that's an auto dialer. That would basically cover any smartphone. This was ultimately won, ACA International versus the FCC, that won this case. The dam breaks. Once that happened, things started to change pretty quickly. And I'll just remind you that the Facebook v. Duguid was right around this time. 2019 is when that started. So right after this, Dominguez versus Yahoo Incorporated, a man bought a recycled phone number and started to receive another user's Yahoo text alerts. And they were like, yeah, let me sue Yahoo, because that's what a reasonable person would do in that situation. And a summary judgment for Yahoo is that no evidence the system could generate random or sequential telephone numbers and dial them. It was the first appellate court to say the quiet part, generate random numbers, which it was able to show that that's not how this message was received, and won the case. This is the first precedent from as soon as the FCC was challenged. This is the first case that actually won based off the definition of an auto dialer. The first incident successfully beating the TCPA, successfully beating the FCC, 2018 here. And again, the floodgates open from here. This is Glasser v. Hilton, Grand Vacations, a timeshare company called from a curated customer list. The plaintiff argued that wasn't enough. And the outcome, using a random or sequential number generator, is what would ultimately make it an auto dialer. And this is the first grammatical analysis where dialing from a list is not auto dialing, more particularly curated from a customer list. Another example was AT&T sent customer survey text from its own internal contact database. And this case was handled by Amy Coney Barrett, which is relevant because at this point in time, Amy Coney Barrett was a circuit court judge and soon, 8 months later, would become a Supreme Court judge and would play a role in Facebook v. Duguid. And so Amy Coney Barrett in this situation states the same about what the definition of auto dialer is to be able to generate random numbers or sequential number generation. And so AT&T won this case, another big company fighting in this instance. And then Amy Coney Barrett in October, this is February 2020, in October, Amy Coney Barrett joined the Supreme Court. And the court case for Facebook v. Duguid was still actively going on. It didn't end until April. And when it did, it was unanimous in Supreme Court, unanimously decided that an auto dialer is a device that must store or produce a number using a random or sequential number generator. So once that goes to Supreme Court, that's basically as just below, it's not going to be an amendment, right? But just below that, this is a Supreme Court case decision that was unanimous in terms of what determines an auto dialer. So in terms of using an auto dialer, what is an automated text message? What is illegal in terms of an automated text message? Auto dialers. Marketing software itself is not illegal. If you're not literally generating random numbers and then dialing them, that's not going to be against the rules. So if your numbers came from a list rather than a generator, you do not have an auto dialer, to put it simple. And this is important to note, this is huge, 9-0 unanimous decision, Supreme Court. And what that court case did is the filings for TCPA cases fell 31% within 6 months, and California dropped by 41%. This is a measurable collapse in terms of the amount of TCPA cases that were happening after that, 2021. So part 4, every door begins to close. This is the era of 2022 to 2024. Plaintiffs try every workaround left, and 4 more circuits shut each one down. So this is when that Supreme Court happened. They're like, what about this? What about this? So marketing platforms stored contacts, applied demographic filters, then shuffle the list before sending. The outcome of this case, not auto dialer, even on a full summary judgment record with the software examined. And in this one, the plaintiff argued that if the software had auto dialing capability, that it would be enough. And the court said, no, the statute bans making a call using an auto dialer. So you must actually use that function. So even if you are capable of using an auto dialer, you could use an auto dialer, you have an auto dialer, if you don't actually use it, you're not going to get in trouble. So plaintiff sees on a footnote in Duguid arguing a generator that picks the order of texting counts rejected. The generator must produce the phone numbers themselves, not the sequence. So even if your system can pick who to contact, it must actually generate the numbers to contact. And then from here, the same theory came back weeks later in a different case and basically reaffirmed that the generator must produce the number itself. The plaintiff's evidence in this case was a company representative casually saying, we use an auto dialer, right? That is not enough evidence of using an auto dialer that also didn't work. And fun fact, TaskBlink with my agency, we use the word power dialer in terms of automatically placing calls to people that are already interested in your services. We call that a power dialer. We try to avoid that word, but even if you did refer to a power dialer as an auto dialer, it's not against any sort of rules. So after Duguid killed the auto dialer theory, plaintiffs pivoted that a text is a pre-recorded voice. That became the new argument. Well, hey, it's a pre-recorded voice. Let's go about it like that. Two holdings: dialing a stored list is not an auto dialer, and a text message is not a voice. That may sound like common sense, but that actually happened. So part 5, a business number is a business number. This is the other half of the fight. If the do not call rules protect homes, what happens when a business publishes its number to the world? So this is a really big court case about this. Bank v. Independence Energy Group, where an attorney sued over marketing calls claiming his line was residential. A line stays residential as long as the subscriber does not hold out such numbers to the public as a business line. Okay? And that is super important. And so this is a very pivotal case here in terms of the wording of business holding it out to the public. And I'll show you some more examples of that as well. And ultimately, this tried to be argued otherwise. And in this case, it was as simple as it was on his business card, his letterhead, and his court filings, with that phone number being associated with the business. And that was enough to win that case. In Shelton v. Target Advance, a serial filer sued over business financing offers sent to a number he used for his own collections business. Okay? And the do not call counts dismissed. Business numbers are not permitted to be registered on the do not call registry. This is in 2019. And so this is just another instance making a separate claim saying that, hey, this person texted me, but it was at a business line and, or, phone call for that matter, and it didn't work because it's a business. So there's different levels to this. The auto dialer aspect, you have are you contacting a business? A lot of this stuff, surprisingly, that I'm talking about can actually even apply to consumers. But in general, this is particularly talking about the B2B SMS marketing, which is what I do. TaskBlink, we only reach out to businesses. So Worsham v. Discount Power, a disbarred attorney and prolific TCPA plaintiff, sued using a number he had filed with a federal court as his business line, dismissed. The outcome was, regardless of whether the number is primarily used for residential purposes, the number is also used for business. This is in 2021. This is one of the most quotable statements of the rule. Your own conduct with a number decides what it is. And in Chennette v. Porch, this is an interesting scenario that is actually still active, not considered a class action. Instead of considered a class action, there's actually 51 unique plaintiffs involved instead of making a class action, arguing in terms of the presumptive residential use of the phone numbers relative to how they were found, where ultimately leading to each individual plaintiff having to prove how that phone number is used in one way or another. And technically, this is consolidated into Dawson v. Porch and is still actively going on. So this has been going on for quite some time, where one side of the argument is that, hey, if we're on the do not call registry, that it should be considered a residential number. And again, keep in mind that a lot of these cases are serial litigators. So they're people that are, they have a recycled number from Yahoo, or they are acquiring numbers, they're listing numbers in an attempt to create infractions. And you'll see later on, as history goes on, how courts have been deciding those types of situations. So this started a while back, and it's technically still active because instead of a class action, there are 51 individual plaintiffs involved in this, and each one is having to claim their individual use of that phone number. And that's really the only thing that's really being determined in that case. But later on in 2024, you can see how the courts are starting to determine this kind of stuff. Ultimately, a company texted trucking businesses using numbers pulled from federal US DOT registrations, a database only commercial operators appear in, and the plaintiffs moved to certify a class action suit, and that was denied. The burden to show residential status is the plaintiff's, and his method of class-wide proof would not satisfy the multi-factor test. One way or another, these numbers were in a database that only commercial operators use and not deemed to be residential, because that's what the actual statute says, a residential subscriber. So what type of phone number is this? How do you know? Is it held out to the public? So on and so forth. How did you get that number? Should know where the number is coming from when it comes to business communication. In Mattson v. New Penn Financial, the Ninth Circuit vacated an early denial of class certification and sent it back for further proceedings in light of Chennette, and the plaintiff tried again. The outcome of this one was denied again. Whether a mixed-use phone is residential or business is an individualized determination based on the totality of the circumstances that prevents plaintiffs from establishing the typality and commonality requirements under Rule 23, where ultimately what starts to happen is deciding what a number is takes a phone-by-phone inquiry, and that is precisely what a class action cannot do. And so what became so important about a case like this, and why is there 51 individual plaintiffs in Chennette v. Porch, is it started to become, over time, increasingly difficult because of this whole business-to-business part and what is a residential subscriber. If you want to pool in 1,000 people for a class action lawsuit, you now need to get not just 1,000 people to cooperate or sign on the dotted line. You need to prove every single person how that phone number is used. You're going to have to prove that against a separate argument. And of course, if it's a business number that's publicly held out to the public, that is going to be very difficult to prove, and also very difficult to prove at scale. It's not going to be an easy process to formulate a class action lawsuit one way or another. So the process of attempting a class action was basically denied, and every single phone number would have had to been validated in this case. This is against Pet Supermarket v. Eldridge, where Florida plaintiffs bounced from federal court on standing, refiled in Florida state court where the bar is lower. 7 promotional texts did not clear Florida's own threshold. And basically what was happening here is that Florida, in this instance, determined that this person wasn't harmed, that this was a matter of prejudice, that this person was trying to enrich themselves in some sort of way. And based off prejudice, based off merit, they didn't feel like this person was actually harmed, which is going to start to become more relevant as we go on with how these laws are changing, especially when we hit 2024 and start talking more about that. Florida walks it back. In Florida, there was a whoopsie in 2021 that basically stated that it really just seems like this was a mistake, saying that selection or dialing on a state basis, there's a problem with that. And then it changed to selection and dialing, and ultimately just barred text claims unless a stop request is ignored for 15 days. So you're not going to be able to make text claims. They're just like, hey, don't sue our businesses over this stuff. We think that this is not as big of a deal as you think. Hey, if you tell them to say stop and they ignore it for 15 days, now you have a case. And when it comes to phone calls, it needs to be a system that is selecting the number and dialing it automatically. Actually selecting it, not just or dialing. That was kind of a mistake that they made there, and they fixed it. This is where the agency loses its grip. And by agency, this is referring to the FCC, where they start to lose really all of their control, deemed by the Supreme Court, all of their control. This is a particular instance that occurred in 2025. The FCC tried, and this will make sense in a second, but the FCC tried to require that consent run to one seller at a time. This eventually just got vacated. And what that means is that one individual subscriber can consent to tons of companies simultaneously. And you'll notice this is Insurance Marketing Coalition versus FCC. So to paint you an example, let's say you want to shop around insurance. You want to see, who can give me the best quote. There are services that will compare and contrast different companies and let you know who's going to give you the best quote and let those companies contact you. You can opt in once and let several companies contact you simultaneously. So that was a big case. This one is a Supreme Court case where this was loosening the power of the FCC, or in general was putting a lot more control to the courts to make their own determination of the statutes themselves, to basically any reasonable agency reading of an ambiguous statute. So you have these statutes from like 1991 that may not be so clear, where eventually you have this Supreme Court case, June 20th, 2024, and then another one where in June 20th, 2025, that's specific to the FCC and the TCPA. This is a pretty huge deal. This is the hinge of the modern era with where the laws are headed. And I'll explain this. A defendant can now simply argue the FCC was wrong. And in 2026, they started winning. To exemplify what that means is that ultimately could look at these laws that were created before text messaging even existed and could now leave it up to the district courts to determine the meaning of the law under the ordinary principles of statutory interpretation. So it was up to the district courts now to interpret what those statutes meant, not the FCC. And you'll see how that plays out. And a lot of things are now happening ever since that Supreme Court case. So texts are not calls, irregardless of what is said by the FCC. And so in terms of what is said, December 2023, the FCC extends do not call to texts. They're saying, hey, the do not call registry now includes texts, okay? But remember, this is December 2023. And in June of 2024, this is pushing more power to the courts, and this is pushing all of the power really to the district courts to determine and interpret the statutes, and really just not giving this level of control to the FCC, where anything that's getting put out is really up to the district courts to interpret it and really come up with your own decision entirely. So when the 2023 extends this to do not call to texts, and again, a lot of this stuff I'm saying, this is just in general, these are the laws, not all of which apply to business, okay? But so what ends up happening here, because the district courts now have all the control, Jones v. Blackstone Medical Services, a situation where a sleep testing company sent marketing texts to a registered number, and the plaintiff sued under the do not call right of action. The outcome was this got completely dismissed, and the court held that a text message is not a telephone call, because the district courts can just do that now. And so this is in 2025. This is what is deemed as the first domino. This decision went up on appeal and became binding law in that particular circuit court. And then again, now we're getting closer, and you can see how the laws are changing and the direction that they are changing. This is now February 2026. A registered plaintiff sues Fenty Beauty over marketing text in one of the busiest plaintiff venues in America. In the judgment on the pleadings that telephone calls does not extend to text messaging, another district court. And this is Radvansky, that will be relevant later. You can see, again, this is the same result in another court case, the same plaintiff, a different defendant, a different judge. 5 days later, same exact result in terms of phone calls and text messages. So Stockdale v. Skymount Property, a homeowner on the registry received real estate solicitation texts and sued. The term telephone call, as used in the section 227, does not encompass text messages. So you're seeing these district courts, and what's actually happening here is that the district courts are like, we have all the control now, and I don't think that a telephone call should be treated as a text message. They're looking at the TCPA and they're like, I don't think this was intended for text messages. I think this was intended for phone calls to residential subscribers. And so the district courts are really flipping and going against the FCC, and according to the Supreme Court case, they're totally allowed to. And every time this happens, every flip that occurs in each individual district court sets new precedent. So this is actually an instance where the defendant itself was actually an SMS platform, a very similar cold outreach vendor, dismissed with prejudice in Florida. One common theme that I see with these court cases in Florida is Florida's like just very much looking at this as like, dude, come on. You're not going to get paid $10,000 for these text messages or whatever amount that you're asking. It looks like you're just trying to enrich yourself, and I'm not going to punish these businesses in the lovely state of Florida. That really seems to be what's happening here. And that's what happened in this instance, is the district court here just ultimately determined that the SMS company, that these claims cannot be fixed by better pleading. And just based off prejudice and merit, they dismissed that case. In this, another example of reaches only telephone calls, not text messages. And that's the outcome of this, even though they're on the do not call list. And here's a crazy one. This is in the last month. So this is July 14th, 2026. This one's kind of crazy. And I'll go into where my stance is, my opinion on all of this. But ultimately, this one is new. This is affecting Illinois, Indiana, and Wisconsin. That basically cold text class actions is switched off entirely. Entirely. A telephone, in 1991, a telephone call meant sound. The first text was sent in 1992. Congress wrote that a call or message elsewhere, and only call, is the right to sue. And basically, the outcome of this case means that in Illinois, Indiana, Wisconsin, go crazy. That's what this says. It's basically consumer, business. It's a text message. You don't have the right to sue. You have the right to sue over a call, but not a text message. And that's what happened July 14, 2026 in the 7th Circuit Court of Appeals. So part 8, where does that leave us? 35 years later, after a law about answering machines, where does it stand today? This is the example that I mentioned at the very beginning of the video. So this is when I was sued, where a web designer with 4 business numbers on the do not call registry sued me, claiming 6 violations and asking the court to fine 19. The judgment for the defendant that targeted listing data uses specific purposeful criteria rather than pure chance or simple counting, not a TCPA violation and not abusive telemarketing. The costs were assessed against the plaintiff. And ultimately, our case at the end of the day are the people that we reach out to are hyper targeted. We use AI to make sure we're reaching out to explicitly businesses, to send personalized messages to businesses, to publicly listed business lines. And I'll go in this later. But this was a slam dunk case where we won. So what does this mean? This is what I'm talking about is not a theory. A motivated opponent tested this exact model in front of a judge and lost. And this happened on July 9th. So that Radvansky case is still on appeal. In the 9th Circuit, they deemed that a text is a call. So most of these situations that are occurring seem to be leading in a direction that is getting much, much better in terms of regulations. And by the way, to note, this is just one part of the rules, that yes, a text message is a call. So for residential subscribers in Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, Washington, if you're a residential telephone subscriber, you can't just send text willy-nilly to consumers, okay? It is also held that an attached video is not a recorded message. So district courts are creating these new determinations. And why this is relevant is because once district courts start disagreeing with each other on a particular topic, that a text is a call or a text message is not a call, it's going to end up going to the Supreme Court. And that hasn't happened at all yet. But this is where it ends. We're up to 2026, up to present day. 2 federal appeal courts now disagree with what a text message is on a statute generating tens of thousands of cases a year. The Supreme Court has taken up the TCPA 3 times in the last 5 years, and every single time it read the statute narrower than the FCC agency did. All 3 times, it objectively is in favor of SMS marketing practices. The law is getting significantly leaner or leaner in general. The Duguid case was unanimous. So ultimately, I do think in terms of where my opinion is on if anything is going to Supreme Court, how is Supreme Court going to handle it? Probably more favorable to an SMS marketer, or at least in terms of commonsensical things. So when I say commonsensical, where do I stand on this? Now I've shared, okay, here's all these statutes and laws. I run a cold texting agency. How do I navigate this? What do we do specifically, right? So for one, we don't use an autodialer. We use targeted, curated lists and personalized outreach. Everything you see below this, these are like, okay, here's why this is completely allowed, right? All these different statutes, you can look it up in court cases, right? We message numbers businesses publish themselves as their business line. Okay, so it's held up to the public by the business, right? We do not message consumers, we message entities. We send text messages. The do not call lawsuit provision reaches telephone calls, depending on the area. And when it was actually tested in court, we won. Okay? So this is our stance in terms of what we're doing. In order to have a claim, you would have to beat all 5 independent aspects of this. Ultimately, with TaskBlink, it's really important to us, and the timing of when TaskBlink was founded, that every single number that we're reaching out to is a number that's held out to the public as a business line. We are sending personalized messages. The TCPA was never intended to inhibit business-to-business communication. That is a huge statement right there, right? Now think about it. Should a business be able to communicate with a new business? Yes or no, right? Now, if you don't have that business's number, how would you expect to get it? You would go online, you would find a number that's publicly held to the public, give them a call, give them a text, right? Reach out to that business to talk about business-related services. That is the only thing we do. We don't reach out to consumers. We don't try and find these like personal numbers that are hidden from the internet, right? We don't do that. The only thing that we're doing is we're finding publicly listed numbers by businesses that are held up to the public, and we are sending them personalized messages, and we're sending this to businesses that we think can actually get value from another client's services. So insert service here, that's going to be able to provide value to this business, these types of businesses, and we're reaching out, sending a personalized message of, hey, here's how we're able to help you, right? And then we help people, the people that we help then help other people, right? And your residential telephone subscriber is nowhere in the middle, nowhere involved. There's no random number generators, none of this kind whatsoever. In fact, we're not messaging people at all. We're not messaging consumers at all. We're messaging entities, right? So that is my stance. And from 35 years ago to where we're at now, every authority in this presentation is public record. The US Code, the Code of Federal Regulations, public court opinions, and FCC orders. None of this is legal advice, but all of this is verifiable. Okay? So if you found this interesting at all, and if you want to hop on a call, if you're running a business and you want to see if you could do SMS marketing, or to see if we could help you with SMS marketing with my company, TaskBlink, feel free to book a call. You can go TaskBlink, like completing a task in the blink of an eye, taskblink.com. You can book a call. And if you're watching this and you're like, damn, there's a lot of information here, I feel like I got a lot of value from this, go ahead, hit that subscribe button. And I would love if you went into the comments and we had all types of debates, or you just want to share your thoughts on this, or if you appreciated this, if you were concerned about certain things, this helps you sleep better at night, whatever it may be, cool, let me know. All right, peace out.